This Creditors in Commerce classroom session, hereinafter session, is the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in this session as applied to the recipient's own personal transactions, cases, or controversy, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in this session. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in this session is relevant to your transaction or that the outcome thereof will be depicted as in this session. The discussion of ideas or procedures in this session is not exhaustive of the subject being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in this session, and the fact that you may not be aware of these issues may have an adverse effect on the outcome of your procedure. It is the responsibility of each party to understand his own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. This session may be redistributed privately by any recipient to another recipient requesting them, conditioned upon the fact that this notice is provided therewith. If you have any questions, you may contact Brandon by email at harmony@creditorsincommerce.com or by telephone at 702-866-9077. How's everybody? Fabulous. I wanted to get some feedback from those of you who have been taking the principles of being a creditor, applying it in your life, in your everyday life, not necessarily through tax forms or anything like that, but on a spiritual level, accepting and bringing remedy. Anyone have anything to share on how it's worked for you? Go. Turn it on.
My background is I'm an attorney, and it's interesting because coming from a creditor perspective, I do a lot of negotiations. And so there was one in particular, actually it just settled this week, but the way I dealt with the other attorney, it was like, okay, we want to settle. My client, I think the difference too is that my client took responsibility, so it was easy for me to step into that role when I represented her with the other attorney. And every time I would interact with the other attorney, it was always ending it with a question. Is there anything else you need from me? How else can I support you to make sure that this gets resolved? What else do we need to do to come to a resolution? And the process was actually really simple. We got through it quickly. And to a point, it was actually fun. I was like, okay, this is pretty much working. And then on another note too, the other day I had an issue with my phone bill with Verizon Wireless. I had this really ridiculous charge. It was like $600, and I was just like, okay, what's going on here? But I called them, was very calm the whole time. I was like, well, how can we figure this out? And by the end of the conversation, the lady on the other line at first was like, well, I'm going to have to send you to somebody else to help you. But then she's like, you know what? So you're a VIP. She's like, we'll take care of you. And she handled it all and cleared out the account and brought it down to $200. And I was like, okay, nice. But it was because I just was coming in from a resolution. It's like, how can we solve it? And again, it was easy. It flowed. So it was because there was no resistance.
Right. Asking questions and pushing towards a resolution. Anyone else have anything to share? Just so you guys know, microphone etiquette, when you're done, just turn it off. And then when you get it, turn it back on so that we don't get background noise.
Something you said last week about creditors forgive debts. Something that I had somebody stiff me for about $2,500. And I've been thinking about finding this person and just thinking about what I would do when I ran into him. and how lucky it would be for me to run into this person. And now, after hearing that, I was like, well, okay, forget it. It's gone. Done. Definitely feel lighter.
Oh, pass to the back.
I have 3 different things. First was after the very first class. I haven't paid any credit card bills or my house payment or my car since probably about 5 months, and it was just blowing up my phone, And the next day when they called, I just answered the call, and I said, well, I haven't worked since October, and I'm looking for a job, but I think I may have one coming up in the next couple of weeks. But I won't really be able to start paying anything until at least March. And they said, okay, well, we'll just put you on a plan. We're going to drop all your interest rates to like 8% and just have you pay like $20, over the next year, and don't worry about it. And they haven't called me since. With my car, it's a little different story. They keep calling just because they're kind of that way. But
Are you asking questions?
Yeah, just asking them, and they just, it's just the same conversation over and over. It's like people from India, But as far as the house goes, I was 3 months behind when, and then I called them the following day and said, same story, and they said okay, and they haven't sent me any notice of default or anything like that. So that's pretty good. And then another story is with the IRS. This is just last week. In order to do this whole process, I knew I needed to match up my what they have as tax records with me filing whatever I'm filing in the 1040s. So I just called up the IRS, and the first time I called, they said the line's busy, call back some other time. Then I called back and I said, I just went through, but I need to talk to somebody. I haven't paid taxes for 4 years. And they said, we'll get you to somebody. and so they put me on the phone with this guy, and I got all of my transcripts sent to me within 2-3 days. It has all the TIN numbers for every accreditor that I have. So that was just a bonus. And then I called IRS Collections and just said, just send me a bill, which then I'm going to accept for value. And it's just easy.
I had an excellent time. I made my first creditor phone call to the IRS, and that was incredible. Talking to them, like, not scared, really. It was really cool. Also, able to, coming into this own thing of being a creditor, there's so much this information about what's going on with the world, and, what can you do? And then someone would ask me, and I would tell them, first thing is you want to become as a creditor. And that's a whole nother world, in balancing your life from all this other gloom and doom stuff, And so that was really good. So I wanted to pass that on.
Thank you.
One thing I liked about what you said, Brandon, was, accept everything, because there's a very powerful spiritual concept, because we create everything that we attract into our lives, and debtors say, no, I'm going to dispute that. And so by accepting everything, it keeps me in honor, and I accept it all because I created it. And I had an interesting story with the Franchise Tax Board. I shared this with you, but I'll let the class know, is I owed $1,600, and they kept sending me notices, and I kept accepting them for value and creating money orders out of it. And they would send me another notice with a slightly different amount. And I realized, hey, my first thought was, wait a second, I already paid that. And then it hit me, this is another offer they're sending me, and since I have unlimited credit, I'll accept that too. And I just kept doing it. Probably happened about 10 or 15 times. And they were all different amounts. So what the Franchise Tax Board was doing was having me pay down someone's liabilities, whoever it was. But after about 10 or 15 times, it stopped. So just everyone know that you do have unlimited credit, and you can do that. Yeah, thank you.
Thank you. Anyone else?
Actually, I went to court. I was on jury duty. this week, and it was interesting sitting there looking at the process as debtor and creditor, and just sitting there and just easily identifying that. It was really powerful, and on top of that, just the whole process here has allowed me to start thinking, like, how do I start creating a relationship with a banker so I can raise their reserves here in the next year in millions of dollars, so they can get their loans and they can produce that. And so the whole process has just been opening up a whole lot of things for me. It's been really wonderful. Thanks.
Nice. And, got to turn it on.
Yeah, one of the things when I first heard about this, I thought it was extremely interesting, and I was very surprised to hear you talk about, kind of like the more spiritual approach to the whole thing. But I had a feeling. I asked actually Lizette about it. I said, am I in integrity if I somehow figure out a way to, collapse my loan and that sort of stuff, which would be great. I'd love it. But am I in total integrity? And that's the only thing that's getting into my head, and I don't have a good answer for it yet. But I'm hoping I can find something that will allow me to do stuff like that and feel good about it.
Yeah, and there's not necessarily an answer. Being in the question is a much more powerful place to be, because there's infinite potential when you're in a question. When you think you have the answer, you've closed yourself up inside of a box, and the answer is the only possibility. So it's a powerful place to be. Thank you.
Time for one more?
Yeah.
I had a similar circumstance where I've been unemployed for 2 years, so I have a lot of phone calls too. And I recognize the numbers for most of them. And I decided I'm going to start answering the phone again. And I was very proud. I saw that 800 number come up, and I thought, okay, here we go. I'm going to be a creditor. I'm going to take charge and quit being a debtor and being in the victim mode. And I started chatting with the lady, and I explained the situation. She goes, oh, I see that. And I said, yes. And I said, when you're 51 and, you've retired from one career, and I said, it was kind of a bad time to switch jobs, and we're going on. And she goes, oh, yeah, you are. And then come to find out, she had the same birthday and the same birth year as me. She said, honey, you're not that old. Now, you just keep going, and you ask friends, and you talk to people, and you'll find yourself a job. And she, all of a sudden, we had this connection. I'm thinking, this is too weird. So we chatted for like 10 minutes. It was really funny. Because you had said, the people at the IRS, these are people. Treat them with respect. So I came from that position, and I was very amused and got off the phone laughing. So she said, oh, I'll make a note here. She said, but you just keep going. You're not too old.
Quite a different feeling when you get off a phone call like that than, answering the phone with an attitude and getting the attitude spit right back at you, right? A point I'd like to make is, if you treat government agents or credit collectors or attorneys or anyone with, contempt or disrespect, what do you expect is going to come back and be reflected to you from them?
Same thing or worse.
Right. And it's not just in the words. It comes from your intention. You can pretend to be nice. You can use nice words and even a nice tone of voice. But if the intention is that you feel contempt or disrespect or anything like that for these people, it's going to get reflected back to you. And that's what you're going to get. That's what you're going to feel from them. Okay, so take that into consideration in all your commercial dealings and all your personal dealings. Because every time you are confronted with someone or a controversy of some kind, there's always a million possibilities of handling the issue. If you don't take whatever you're confronted with personally and you can step outside of it, then you're able to approach it as a creditor. How do I'm here to assist. I'm here to bring the remedy. instead of taking it personally, which then may have you react and may have you get angry or anything else, keep it impersonal. It's not, nobody's personally attacking you ever. Even if somebody comes up to you and starts screaming and yelling in your face because of something you did, that confrontation is about their experience and reaction to you. So you can choose to take a defensive mode, which would be like what a debtor would do. A debtor gets defensive, wants to explain himself, wants to be right about something, whereas a creditor doesn't need to be right about anything. The creditor, in infinite possibilities, is ready to bring a solution in any way, shape, or form without taking it personally. I wanted to maybe get in tonight. Oh, wait, hold on. Let me see if, yeah. Anyone on the phone have anything to share about being a creditor?
Yeah, Brandon, this is Justin. Can you hear me?
Yes, we can.
Yeah, it's just, I've shared this with a couple of people in the group. I mean, for me, my experience is just, it's just a much lighter world to be in, as opposed to the combativeness and the upset and all the make wrong and stuff. So this whole thing with the creditor to me is kind of like the pot of gold at the end of the rainbow. So that's pretty much been my experience so far.
Nice. Anyone else on the phone have something to share?
Kim Marie here.
Hey, Kim Marie.
Can you hear me, Brandon?
Yep, we can hear you.
I had two of the best conversations I've ever had with the IRS in the last 2 days. And basically, I acknowledged this woman for being the best bookkeeping agency on the planet because I didn't have access to my 2005 tax return. And she spent about an hour on the phone with me gathering all my records that I needed to take care of my balances and my outstandings and everything. And we were laughing and joking and talking about our families, and it was just like, I mean, we almost didn't want to get off the phone with each other. It was just a completely different experience than I've ever had dealing with the IRS.
That's great. Anyone else? Alrighty. Okay, so I thought tonight we'd maybe get into administrative procedure. Okay, administrative procedure. All of us know about the bankruptcies: 1789, 1859, 1929, 1999. Administrative procedure is the codified system that governs how agencies, both directly in the government as executive departments and independent agencies, can interact with each other and with you or with your corporation. Okay? The Administrative Procedures Act from 1946, right from the bankruptcy of 1929, we had just in the 30s the creation of something like 18 administrative agencies of the government. Okay? Up until then, if we go back into history, before the Civil War, there were 11 agencies, administrative agencies created by the government. And then after this, between 1865 and 1900, we had about 6 additional agencies that came into existence. And then between 1900 and 1940, we had over 35 administrative agencies created, a bulk of them, 18 of them, created just in the 30s with Roosevelt and his Democratic Congress. We have a Democratic president now. Do we have a Democratic Congress now? Think we'll get some more agencies? I bet you we do. So with the in 1946, they came up with the Administrative Procedures Act, and the Administrative Procedures Act was a way of just setting a standard for how these agencies can interact and how people can interact with them. And I don't know if you've ever heard me mention, or if you've heard maybe Jack mention or someone else mention data integrity boards. Okay? The way that the administrative procedures work and the way that you are able to interact with these agencies, it's basically each agency, including independent agencies, have the capacity to serve an executive and judicial role in decision making and in business dealings. Okay? So, for instance, the IRS has its own system of administrative procedure under which is governed by the administrative law in general. So when any agency is interacting with the IRS, or when you're interacting with the IRS, or when you're interacting with any other government agency, these system of rules govern how you can interact with them. Okay? And last week we discussed records. Records are essential in the administrative process and in dealing between agencies, or when you're dealing with agencies. Some of the things that we'll be discussing tonight, and if you guys get to the documents, I got them up late today, so I'm sure not many of you had the opportunity to print them. But I have in there a little Administrative Procedure Act. It's basically like an encyclopedia article. It's right out of Wikipedia. And it goes over a little historical background and the basic purposes and whatnot. But there was, I forgot to highlight it, there was something of interest I wanted to mention on here. Okay. I'll read the introduction here. The Administrative Procedure Act, APA, is the United States federal law that governs the way in which administrative agencies of the federal government of the United States may propose and establish regulations. Where do all the regulations come into effect? Does anyone know? Anyone ever heard of the CFR? Code of Federal Regulations? Okay, that's the codification of all the administrative processes and how these agencies can interact with not only your corporations and you, but with other agencies as well. Administrative government proposed establish regulations. The APA also sets up a process for the United States federal courts to directly review agency decisions. It is one of the most important pieces of United States administrative law. The act became law in 1946. That's when the Administrative Procedures Act was passed. It was a culmination of everything Roosevelt had done up until that point with the Democratic Congress. It would have probably been perfected a little earlier, but we went into World War II right at the end of the 30s. And so the Administrative Procedure Act actually didn't get completed until after World War II. The APA applies to both the federal executive departments and the independent agencies. U.S. Senator Pat McCarran called the APA a Bill of Rights for the hundreds of thousands of Americans whose affairs are controlled or regulated by federal government agencies. The text of the APA can be found under Title V of the United States Code, beginning with Section 500. So for those of you who want to go look up the Administrative Procedure Act, I have some links in the documents that we included in the downloads for tonight. There's some definitions in there that come right out of the U.S. Code, Title V. But what I think we'll discuss tonight is the presentment process through a notary. A notary is a witness. They witness oaths. They witness signatures. They witness dishonors, acceptances. Okay? As a witness, and their actions are governed by these regulations. Okay? And as an official, their records as a second witness can basically serve to authenticate and certify your procedures. Okay? So, for instance, if you were, let's say you had a claim against someone and you wanted to do a private process as opposed to a public process. If you have a claim against someone, what is an example of a public process? A lawsuit, right? A complaint or something of that nature. A private process would be, remember we have jurisdiction A and jurisdiction B. Jurisdiction A being in the private, that's where our private process begins. Okay? Now, a notary happens to have the unique potential and capacity of serving in both jurisdictions. If you go to the California Government Code, you'll see that a notary public may perform any of their duties without the United States or without the state of California. Okay, what that means is they can perform their duties in jurisdiction A without the United States and without the state of California. Those are public entities. So they're basically saying a notary can be outside of the public and perform her duties. Okay? Now, the reason I may get a notary involved with my claim is that the notary is going to serve as my second witness to my procedure. And then I can establish public records that will back up my private records. My private records are going to be self-authenticating, like a claim. So, for instance, I have a claim against Bob, and Bob owes me services or let's say $1,000. Okay? So, rather than just sending an invoice to Bob, okay? Now, in the public, is sending an invoice enough for your public procedure? Not necessarily. But could I successfully prosecute an overdue invoice in court? Yeah. With no other proof other than bringing the invoice in. I don't have to have a proof that I mailed it. I don't have to have proof that there's any debt there. I could just print up an invoice, use it as the foundation of my court case, and if the opposing party doesn't answer or defaults, I'll get my remedy with just that invoice. Okay? Now, when you're operating from jurisdiction A, just an invoice isn't going to be very effective because you don't necessarily have the courts to enforce your private process. If you want to operate over here, you're going to get your judgment over here and then bring it over here. So you're going to get your judgment in A and bring your judgment into B if you want to enforce in jurisdiction B. Okay? Now, if Bob owes me $1,000 and I contact my local notary and I ask my notary to make a presentment, okay, can a notary prepare documents for you? No. They can't even prepare the documents that you're using in your process that have their name on it. That would be practicing law. So a notary cannot prepare documents for you. Okay? So if you're ever dealing with a notary and doing presentments, you are responsible for preparing all of your documents. Okay? So I contact my notary and I tell her that I want to make presentment of something without the United States and without the state of California. Okay? And I put together a letter of presentment for my notary. Okay? The title on it may be Presentment of Notice and Claim under Notary Seal. Okay, this is actually in the examples for tonight's downloads. I have them here grouped online. They're also grouped. You may have to look at them to figure out which documents go with what, but it's a numbering system. So you'll see that there's process 101, and 101 has maybe 4 documents with it, and you'll see they each have different names, but they all have 101 in them. And then step 2 of that process would be 102. And then the next process would be 201, and step 2 of that other process would be 202. So you guys, they're kind of grouped together, but I'll hopefully from what I give you here, you'll be able to distinguish what we're talking about. Do you have a question?
Quick question, just for definition purposes, what is considered presentment?
A presentment is, okay, that's actually what we're going over. So we'll go over in a little more detail. A presentment, when I approach my notary to make presentment for me, what I'm saying is I'm going to give her a claim. My claim will probably be sworn and have an oath on it, and she'll seal the oath, but that's not the only document she's going to be involved with. Okay, my oath could be my affidavit, could be my claim, could be an affidavit of obligation, which you could then later turn into a lien. But basically, so the first step of the process is my claim. I draft my claim in the form of an affidavit, and I get the notary to do a jurat on this document so that it's a sworn affidavit. Okay. Then I prepare a letter of presentment for my notary, and the way that this letter is structured is that the document is from the notary. Okay? It's to whoever you have your claim against. Okay? You could put like a regarding line in there if it is in regards to a specific account, let's say, that, or if it's in regards to a specific business dealing that you had with this person. So let's say Bob owes me $1,000, and Bob owes me $1,000 because I gave him my car. And we had a deal that he was going to pay me $1,000 for that car. Okay? So I may put on there regarding vehicle with this VIN number or something like that. And then it has a little line on here on the type of service that this presentment is being sent as. I recommend that whenever you're operating over here from jurisdiction A, the private, to make your claims, that anything and everything that comes out of A and into B needs to be by registered mail, return receipt, not certified, registered. Okay? Now, does anyone know why registered over certified?
Does it have to do with being the postmaster of your document or registering it as an asset?
It has something like that to do with it. I would say the reason why we use it is that certified is only for jurisdiction B to jurisdiction B. It's a benefit and privilege of being an entity in jurisdiction B. Okay, so if you're using certified mail, you are in jurisdiction B. If you're using registered mail, you can be in A and send it into B. Registered mail will work from the republic to the democracy. Okay? I don't know what that means.
Safe. Like it's never out of a safe environment. It goes from a safe to a signature to a
Oh,
carrier.
yeah. The way that it's transported is literally from one
locked envelope carrier to another carrier. Every single carrier signs for the mail. It's the most secure way of sending mail through the Postal Service. There we go.
Isn't another reason why we send stuff registered is so that if we're in a court case, it actually shows up in the judge's documents and not just the court clerk's?
If you were sending your evidence to court?
Yeah, something like that.
Yeah. If your evidence is coming from jurisdiction A, how are you going to send it to the court? Registered mail. Under notary seal. You would literally make a presentment to the court. I wouldn't put it in the form of a claim like you're going to have the judge's house or something like that. It would just be a presentment of the evidence. So rather than the letter saying presentment of notice and claim under notary seal, the letter would say presentment of evidence under notary seal. And then the letter may say something like, I've been contacted by John Henry Smith from outside the United States for the purpose of presenting evidence under notary seal. Okay? And then there may be, typically on the presentment letter, there's going to be a statement on there about what the notary is going to do with your response. See, remember the presentment letter is from the notary. The notary is instructing the other party in this letter that any and all responses are to go through the notary. What is the notary? A witness. So the notary is going to witness their response. Okay? So, and then you may have something on there that says that if a response is not received within 10 days, 14 days, whatever timeline you want to give them. Now, typically in jurisdiction A, if we're operating in Admiralty, when I make presentment of a claim, there's a 3-day turnaround from which that claim must be answered. Okay? But if we're sending it through the mail, we have to account for 3 days out and 3 days back and a Sunday. So that's why 10 days is a very typical timeline if you're doing presentment of a claim through mail. You're giving them really only 3 days to respond. But because you have to allot for the time of the mail moving, the statement may say something to the effect of, your response to the claim is to be received through me no later than 10 days from this postmark to prevent issuance of a certificate verifying your non-response or default pursuant to my statutory authority. So, there's a statement right there in the presentment letter telling whoever you're sending this presentment to that if there is no response in 10 days, they're going to certify that non-response or that default. Okay? Now, you may also have in your notary presentment letter what would be considered defective response. If I receive anything but the money you owe me, that's what does the IRS like to call your responses? Frivolous? When it has no meaning to them? Like if you get a notice of lien and levy in the mail and you draw Mickey Mouse on the front of it and send it back, that's a frivolous response. Okay? So you can define in your letter of presentment what is an acceptable form of response. And that if it is not in that form, the notary is going to certify that as a witness that you defaulted. In fact, isn't a defective response the equivalent of a non-response? Right. When you get a notice of lien or levy from the IRS, is there a lien? Not yet. When is there a lien? When you don't respond. Or if you respond with Mickey Mouse on a piece of paper. Keep that aside.
Share this with you, Brandon, privately, but I want to bring this up to the class. If you ever get a notice of lien from the IRS, and this happened to me, just accept it for value because the response places you in honor, and they therefore do not file the lien.
And what did you do by accepting it for value?
I gained title to it. Exactly.
You control the transaction.
Yeah.
Now, if he were to write across the face of it, refused for cause, that could be considered a dishonor. And they could still perfect their lien against you. But when they sent the notice of lien and it had on there that you had 10 days to respond or 30 days to respond or whatever, as soon as that timed out, somebody certified your dishonor. And that's the lien. You'll never see that in public. They'll take the same notice that they sent to you and they'll file that into the public record. But the actual lien, which is a third-party certification of your dishonor, you won't see that in public. So, by that logic, do you ever want to put your certifications of someone's dishonor into the public record?
No, not unless you want to give up title.
Yeah, not unless you want to give up title to your claim. Okay? Now, so we've set the terms of the response. Okay? And we've clearly illustrated to the recipient what's going on with our letter of presentment from the notary. Okay? This is an example of an affidavit claim that may be attached to that. Now, I wouldn't actually have them stapled like this. I just did this so that I could separate the presentments, and I could work with this one, then this one kind of deal. So, this is my claim. Okay? This is just an affidavit. It'll have a jurat. It'll be signed. It'll have my signature on there, sworn statement. Is this the claim? Or, better question, is this an effective claim? Can I enforce just this document? No. I could try, but it's not going to be very effective. It'd be like having an invoice with no signature on it. Affidavit is hearsay. So you say. That doesn't mean anything. Okay? Does anyone know when this becomes your claim?
A couple more steps. I think when you have the documentation from the other page that you've sent and presented it.
Right? Yeah. It would be your. Remember in the presentment letter, the notary illustrated that she would be certifying the dishonor or the non-response, right? That certificate attached to this claim is what makes this claim. The actual certificate from the notary as a third-party witness to what happened is actually your claim. But you would attach that to your affidavit. Should you send your original affidavit to the person you're making the claim against? No. Yeah, you want to keep that because you're going to take that original and attach the original certificate of protest to it. Then you've got a claim.
Is that a security at that point?
It could be. Depends what you do with it. It is a security at that point. Okay. This is actually, this first presentment in the example is a two-pronged presentment. It's actually a claim that's establishing a record. See, this one is a commercial affidavit, and it's establishing facts. If these facts go unrebutted, or there's no response, then the other party is acquiescing to these facts. It's off.
Let's say you create an affidavit, a plain statement of fact. You have that notarized. You send it to your opposing party saying, if you do not respond to this within 30 days with an affidavit of your own, sworn on your own commercial liability, then you're in dishonor and you agree to the terms and provisions therein. Let's say they don't respond. In order for that affidavit to be perfected, you need a certificate of protest.
Yes.
Otherwise, the judge would say, what is this?
It's hearsay.
I see.
It's hearsay. It's just you say so.
Right.
So what? You say so.
Even though the other person can't produce an affidavit? Doesn't matter?
What's an affidavit?
Well, I mean, they would have to say, well...
But what I'm saying is, see, it's not the affidavit where your claim is, or where the power of your claim is. Because it's just hearsay.
It's dishonor.
It's just what you say.
Right.
And if they haven't, how do we know they haven't rebutted it?
I see.
See, the notary serves as a witness and is certified that they acquiesce to these facts. So it's not the list of facts that's the power. It's the notary's witnessing of their non-response to this.
Got it.
Okay?
Thank you.
So this one was actually establishing the facts about a payment. There was actually, this was like a process after we had made presentment of an instrument, a private instrument for payment of a debt, and after they had refused it and sent it back, we sent it back again going, making sure they knew. Did you know if you return an instrument that's been put in on a debt, you're agreeing to that debt doesn't exist, that debt's been settled. If I send a check in for, if I get an electric bill, and my electric bill is $100, and I send them a $100 check into the payment center, and they send it back, and then try to send me a bill for $100, I can dispute that. And that charge should go away because they agreed, when they sent me my check back, they agreed that there was no debt. So, just to make sure they know how commerce works, I wanted to establish some facts about that payment. Okay, so that's what this commercial affidavit is. And I also included in the UCC section, Title 9, Section 210, or Section 9210, there is a what's called a request. That section pertains to what's called a request regarding a statement of account. And what it says in the Uniform Commercial Code. Now, if I were making this presentment and I was going to actually quote the UCC, I wouldn't actually quote the UCC, because who's bound by the UCC? Nobody. It's only when it gets codified into the states. So really, if I'm talking about Uniform Commercial Code Section 9-210, I'm really talking about California Commercial Code 9210. Interesting how they have the same number. But basically, the UCC was adopted by the state of California as the California Commercial Code. Okay? And a request regarding a statement of account, if you look, you can see there's basically a little statement of account on here. I'm sending them the statement of account showing a zero balance. They sent me the payment back, so that must mean there's a zero balance. If they do not rebut this with a verified statement, does anyone know what verified means? I'm sure the attorney does. Sworn under penalties of perjury. If they don't send me a rebuttal to this, saying that I owe more than $0 with a verified statement under penalties of perjury, this stands as the statement of account. Okay? And they have 14 days to respond to this. So my notary presentment letter actually mentions both documents. And I read you in regards to the claim what the notary said and for non-response. And what the notary has to say about this particular document is that your response to the request regarding a statement of account is to be received through me no later than 14 days from this postmark to prevent issuance of a certificate verifying your non-response or default pursuant to my statutory authority. So, if I get a third-party witness to witness their non-response to a request regarding a statement of account, I've now got a statement of account for $0. Not the statement of account by itself, But when this statement of account is attached to a certificate of non-response, it's a claim. I now have a claim, a receipt for a zero balance statement of account. Okay?
Brandon, would it be helpful to actually define the notary's position in the private and what they represent in the old code?
We'll get to that. Okay, so, and if you read the code, you go to section 9210, there are some elements on there that you must include. Okay? For instance, the collateral. If there's collateral secured by that debt, it must be listed on here. The creditor, the debtor, the date of the statement of account. So the date of my statement of account is the day that I send this out. So if I send this out on October 14th, this is a statement of account showing a zero balance as of October 14th, 2008. Microphone.
Brandon, I know you mentioned that as a cure for insomnia, we should read the UCC. But is there, in your travels, is there a guide? I know some people out there in the movement have written their sort of authoritative interpretation of the UCC. Are there any good ones out there that you would say, hey, check this person's stuff out regarding the UCC?
I mean, there's tons of. I mean, we'll be sharing lots of documents in the class and whatnot. And there's a lot available on the private network of the website. But what I would recommend, like there's cracking the code and stuff like that. I don't know if it actually deals directly with the UCC codes, but I think the best way to at least get a roundabout idea of what's going on in the UCC is just go through it. And I don't mean read it starting with Title 1, Section 1, Paragraph 1, all the way through to Title 9 or Title 10 or Title 11, Section whatever. What you should do is just kind of look, like go to the index of the UCC and check out, okay, Title 1 is this. Title 2 is this, Title 3 is this, Title 4 is this, and then you'll get an idea of how it's broken down. So you'll know, if I want to learn about securities, Title 8. If I want to learn about secured transactions, Title 9. If I want to know about negotiable instruments, is that Title 3? 3 or 6 or 4? Warehousing and Title 7. So it's all in there. And maybe you'll go to secured transactions and then just look at the subtitles in there. And you'll get an idea of how it's broken down so that if you're ever looking for something specific, like I knew I was looking for this, and I knew this had to do with secured transactions because I was looking for something having to do with collateral and a statement of account. And sure enough, there it is right there in Title 9. Okay? Alrighty, and then the last document of this presentment is Notary's Certificate of Service. Okay? Notary's Certificate of Service basically says, it's like an affidavit, just like the Certificate of Service, your Certificate of Protest, Certificate of Dishonor, Certificate of Non-Response, they're all basically affidavits that are being signed by the notary as a witness. Certificate of Service, the notary is witnessing what went into the envelope. The notary mails it. So the notary takes all of your documents, copies them, puts them in the envelope, seals it, and mails it out, and keeps a record of everything. Okay? Now, is this a public record if the notary keeps a copy of this? No. It's the notary's private record for presentments, if the presentment is coming from over here. Okay? Now, what about the... Oh, there's a question in the back.
Now, I actually tried to do this, getting certified copies just of my birth certificate, accepted for value, and the bond and the cover letter. And the first notary I talked to said they didn't do that because they just wouldn't do that. I called another notary. They said they would do it, but then they wouldn't necessarily send it registered mail. Is there another way?
What do you mean? You pay them in advance for the registered mail. Were they not going to send it because it's too expensive?
No, I think it was just because they weren't affiliated with they were in a mailboxes center, which is a public.
Okay. You do the work.
Okay.
When you bring them the envelope, it should already have the registered mail sticker on it.
Yeah, no, it did. It had everything on it. They just.
What's the problem?
I don't know. That's what I was
She didn't
wondering.
want to drop it. She didn't want to go to the post office.
Maybe.
Okay. Yeah, because to send registered mail, you have to go to the post office. You can't send registered mail through a mail center. You can send certified mail through a mail center, but not registered. Why is that?
Service.
Yeah, the person working at the mail center doesn't have the authority to even handle that mail. Yeah, they don't have something to lock it in. They're not going to sign as being responsible for it. Okay? So your certificate of service, basically affidavit stating who you sent the materials to and a list of the materials you sent. The notary's record should be a copy of everything that got sent. You should keep all the originals. So you should have the original certificate of service, the original statement of account, the original affidavit, and the original presentment letter. Okay? Send copies out in your presentment and give a copy to the notary for her records. Well, actually, your notary is probably going to have to make the copies because the notary needs to sign and seal 2 of these documents. Actually, 3 of them because there's a jurat on one of them. So the notary's record is how we can take evidence from A into B. The notary, because the notary certification of the records means they need to keep a copy of that record. How can they witness or testify that that's what got sent if they don't have a record of it? Okay, so keep that in mind, those of you who are notaries. You must keep a record. Keep thorough records. Okay? Now, this is the initial presentment. That's it. These 4 documents. Okay? 10 days later, guess what? Bob didn't respond. So, now remember this presentment we actually had 2 documents that the notary was certifying your response on. The request for a statement of account and the affidavit. Okay? So we've actually got 3 certificates here. Did I print all 3 of them? No, I didn't print all 3 of them, but there should be 3. There should be 3 here. I may not have included the 3rd one in, it looks like. First, you're going to send a notice of the default and a notice of the dishonor. Okay? Now, that gets sent from the notary. The notary said that if in 10 days or in 14 days I don't get your response, I'm going to certify your non-response. So the notary, as a friendly reminder, now, who prepares this document? You do. Okay? So this notice of default, the notary signs and seals it, you prepare it, and it basically has all the information on it that's going to be on your certificate. Okay? That on such and such a date, this person, in care of this address, presented these documents, dated this date to this person, signed by this person, requesting, and actually I'll read through this one since it actually is relevant to what we had. So you see up here at the top, State of California, County of Orange, and it's got a little subscribed and sworn. What do you usually see that at the top of? Affidavits. Affidavits. Whenever a notary, a lot of times you'll see it in a notary's acknowledgement. And what does the last line of the acknowledgement say? I declare under penalties of perjury that the foregoing paragraph is true and correct. That's a mini affidavit. A notary acknowledgement is a mini affidavit. That's why it's got this little heading at the top. Okay, so notice of default. Presentment. Be it known that the person signing below a duly empowered notary public at the request of John Henry Smith, in care of the notary's address, did duly present on October 14th the instruments, request regarding a statement of account, and commercial affidavit. Dated October 14th to Tom Jackson of BAA&C Home Finance, 101 Yorktown City, State. That was under the subheading presentment, all that what I read. The next subheading is protest. You guys have heard of a notice of protest or a certificate of protest? Protest. Whereupon the notary public signing below for the reason dishonor by non-performance/non-response does publicly and solemnly certify the dishonor as against all parties it may concern for default on the instruments by reason of non-performance/non-response thereof and the stipulations therein. So remember we were talking about how the letter of presentment had stipulations in it of what we would accept as a response. But your affidavit could also have what we would accept as a response. And your request regarding a statement of account could have the same thing. Okay? And then, so now we've got presentment, we've got protest, and the next subheading, notice. The undersigned notary public certifies that on November 6th, this is after the presentment date, so this is after they have defaulted, notices of default were sent to the parties noted below by depositing in a depository of the United States Postal Service within the state indicated herein a sealed envelope containing said notices directed to the respective persons or entities at the last known corresponding address below. Name of who we presented it to, address of where we presented it. Last subheading, testimony. So this has 4 elements to it: presentment, protest, notice, and testimony. Your certificate of dishonor or protest has those same exact elements. Okay? This is actually the notice of default it's talking about on the notice line. This is it. Okay? Testimony. In testimony of the above, I have signed my name and attached my official seal. In testimony of the above. What's she doing? Witnessing. Okay? And with that notice of default will go a certificate of service. Certificate of service is going to have the notice of default listed and the certificate of service listed. The certificate of service lists everything in the envelope. If you put another envelope in the envelope, that envelope is listed on here. Okay? So, and the way I do it is right here, I always have the certificate of protest as the last item on the list. And right here it says, number 2, because there's only 2 items, reference copy of this notary's certificate of service, in parentheses, signed original on file. So I don't even send them a signed certificate of service. Oh, we're out. Okay, we need to switch a tape. All right, we're back. Okay, so on the certificate of service also includes the service information. Okay, there's a little statement right here below my list of things. Actually, I'll just read the thing to you because it's a very short one. The heading, Notary Certificate of Service. It is hereby certified that on the date noted below, the undersigned notary public mailed to, name and address of who it's going to, hereinafter recipient, the documents and sundry papers pertaining to a certain account number, 123, regarding Barney F. Rubble as follows. Item number 1, notice of default dated on or about November 6, 2008. Item number 2, reference copy of this notary certificate of service, signed original on file. by registered mail number, and it lists the registered mail number, return receipt, attached by placing same in a postpaid envelope properly addressed to recipient, and at the said address, and depositing same at an official depository under the exclusive face and custody of the United States Postal Service within the state of California. So, again, it's an affidavit. It is certified that documents were mailed to this person, name the recipient regarding this, these are what got mailed, and here's the number, the tracking number for it. So, what I like to call a complete claim is not only will it have your certificate of protest, which is this document here, it'll have a certificate of protest, it will have all the supporting documents, so it will have your original affidavit, your original certificate of service of the original presentment, maybe your notary presentment letter, the notice of default, the certificate of service for the notice of default, okay? All of those documents together along with certified copies of my return receipt, which is Form 3811 from United States Postal Service, and my registered mail receipt, Form 3806. Okay? So it would include all of that. And then I would slap an apostille on top of it, or a certification from the Secretary of State, making it a self-authenticating claim. Okay? So all of that evidence together is, now if I wanted to, with all of those documents, what does that comprise? If I've got all of those documents together as one packet, what does that comprise, you think? Not only a claim, but I have a third-party witness to every element of the claim. If I have a third-party witness to the entire claim, isn't it essentially a judgment? And if we go into administrative procedures under the code of under Title V, you'll see that that's what they're doing to you. It's not that the bank has any claim on your house. It's that they get you involved in a commercial process where you default on the commercial process. That's how they establish the claim. And every time you receive something new in the mail, it's a new offer. A new claim is being established. Whether it's a notice of lien, notice of levy, even your mortgage statement. It's an offer. Don't they give you so many days to respond? When you don't respond, don't they take some other further action? Okay? So this administrative procedure that we just discussed of going from A to B, it's going on in B all day long, every day. It's just their records are all standardized forms, standardized documents, standardized formats. Remember when we talked about jurisdiction A and B in form and substance? Everything in B, the democracy, is form. There is no substance. Everything in A is substance. So when the IRS perfects their lien against you, doesn't the IRS get to sit on the fence between these two jurisdictions? Maybe that's why they don't have to show you their claim. Whereas a bank's administrative procedure, typically, they'll show you the claim. Not always. Sometimes they'll just bring an invoice.
I'm going back a little bit from what you just said, but the process that you just described, at what point does it go into jurisdiction B? Because from what I was looking at, you were still in the private. Is it when you put the apostilles into the Secretary of State? Does that... It's still private. Even after I've gotten the apostille and the certification and everything, it's still a private claim.
Okay.
Okay?
So we haven't even gone into
No.
B yet.
Yeah, because I could take
Thanks.
that entire claim and put it with a new presentment letter, and that one I would call presentment of evidence under notary seal, and I can bring it into a jurisdiction B court and get a judicial review of my evidence, and then get some writ out of the court based on a judicial review of my private evidence, private proprietary evidence. And I would, in my letter for that, I should have included one of those, because I've done those before, and I do have already prepared notary letters for submitting evidence. And the way that you structure it is you're clear that it's private proprietary documents. That if the judge or the clerk were to put these documents into the public, it would be harming your private rights. Okay? It is a private proprietary process. That's why it must go in under notary seal into judges' chambers. Judges' chambers is the private side of a court. Okay? If it doesn't go in under notary seal into judges' chambers, you could lose it to jurisdiction B, and they would then have title to your claim. Can you pass that back?
That seems to be bringing up an important point, and that is, let's say you had some form of information that you did not want put into the public record. In order, let me rephrase that. To prevent someone from bringing it into a public forum, i.e., or e.g. a lawsuit, you would put private on that document. Then they can't use those documents in a court of law against you.
Yep. I have a couple stamps. I have one that just says private. I stamp that a lot on things like the envelope. My registered mail envelope will typically have a red private stamp on it. I also have a red stamp that says private. I think it just says private, not for public filing. And I typically stamp that on anything I'm sending into the court on the private side. And it's funny because I actually got a call from a clerk. I'd gotten my evidence into a court case, into chambers, and I was going to attempt to use it, but I had created a civil case where I didn't have any statutory, I wasn't doing anything in accordance with statutes, so I kind of basically, I separated myself from my remedy. So I created a case over here, and my remedy was over here, and I couldn't bring them together. Okay? Now, after the case, a couple weeks later, the clerk calls me. And she goes, Mr. Adams, we have these documents here that are stamped private, not for public filing. Would you like to come pick these up? Because we can't file them into the case. But the judge held them for 4 months until then.
120 days.
Well, I'm actually estimating, but basically the judge held them from the time he had those documents from the moment I started the case. But he didn't release them until we were done with the case. And then, because I put on there that this is my private proprietary evidence, oh great, this is going to turn into something fun. So because I had put on there that it was my private proprietary evidence, the judge did not put it into the public record. And then he held on to it because in the notary's presentment of evidence under notary seal, it states that this is to be held as evidence that there's going to be public filings that call upon this private evidence. And the private evidence had the apostille and everything on it, so it was a self-authenticated judgment. But because I created a civil case over here in B, there's no foundation for me to get a judgment from A over here into a civil case in B. I would have to take that judgment from A and bring it into B under judicial review or adjudication. Okay? Because I'm seeking an order or a writ, not necessarily a benefit privilege of filing a civil case. Go ahead.
Brandon, can you explain how you can traverse into B and get the public to recognize the Jurisdiction A document to enforce a commercial claim in the public when it originated in the private?
Okay. Records. Okay? If I've got a claim against Bill, my private claim, okay? Let's say on my affidavit, I said something to the effect of, if you don't respond or pay me within 10 days, you're agreeing that I can file a UCC1 filing on you as the debtor. You're agreeing to that. So, Bob doesn't respond. I now go into Jurisdiction B and file a document there known as a UCC1. I list Bob as the debtor, me as the secured party, and the collateral, whatever I want to list on the collateral, or whatever Bob agreed to in the affidavit. I may say in the affidavit, and you agree that your house is going to be collateral on that claim. And then I go file it in the county. I've now got a UCC1 claim against Bob in the county with his property listed as collateral. What can I do? I could foreclose on him for that $1,000 debt. Because of the public record, though. Not because of my claim. This claim never makes it over here. I don't attach this to my UCC1. UCC1 is just a notice. But remember, in Jurisdiction B, what matters? Form. They don't want your substance. Leave that over there. It's all about form. So that simple document recorded into the county is all I need. Now, if he tries to challenge my lien, what's the only way he can remove that lien?
To satisfy your original stipulation?
Besides that, let's say he doesn't want to satisfy it and he wants to challenge it. He would have to actually get a jury to remove it. And guess what? And guess what happens? When he takes it to court, what am I going to send into judges' chambers? My claim from Jurisdiction A. My private evidence. And no matter what Bob says in the court, it ain't gonna go over my claim. Because whatever he says over here is going to be what? Hearsay. He's not going to bring any evidence in under the rules of evidence that can contradict my evidence. And my evidence, if I presented it under notary seal, it's self-authenticating with the notary seals and the Secretary of State certification on it. It is a, what's the word I'm looking for? It's not superior. It's a, oh my God, I can't believe I'm totally blanking out on the word.
Starbucks?
No. It's, no. Stop. I know. It's an exception. It falls under exceptions to the hearsay rule. Okay? Because it is a claim, right? Right? Isn't my certificate of protest just an affidavit by the notary? Well, how come her affidavit has more weight than Bob's affidavit? Not only is she the witness, but it is her duty to keep that record. And if you look under the exemptions or exceptions to the hearsay rule, if that record is a record that is part of some third party's record-keeping process, or their official record-keeping process, you can bring that in, and it would be an exception to the hearsay rule. But Bob doesn't have anything like that. So anything Bob brings into the court is going to be hearsay.
What if Bob was a creditor?
What does that mean?
Well, and did put a claim together like you did and put that into the court again.
Oh, so we're going to have a paper battle? First one to leave the battlefield first loses.
So a recontract, you would just be in an acceptance and
Of course. Anything Bob sends to me, I'll accept.
Does the jury see the private evidence?
No.
So
But who really makes the law in a court? The judge.
He's already in default, though. There's nothing he can do.
Right. Not only that, I've got a UCC1 claim on him, and I've got the evidence over here to back it up. So the judge is going to basically instruct the jury, you will not overturn that UCC1. because all Bob has done is give us a bunch of hearsay. And hearsay doesn't refute the facts. See, my UCC1 stands as fact because of the evidence that supports it. Okay? Yeah.
So let's say that Bank of America goes into default, and I have my stipulation that their executive headquarters in North Carolina now becomes collateral. I can file a UCC1 in that state.
Yep.
Put a lien essentially on their entire headquarters building and foreclose on them. That's power.
Yeah. Not only that, let's say you have a claim against Chrysler.
Right.
You show up at the docks with your claim and say, these cars that you're unloading, keep them here. I'm seizing these vehicles. Okay?
That's what the IRS would do.
Yeah.
Or any other.
Go seize it. Bond the sheriff. Have him go seize it. For like $500, or it depends on what the sheriff's seizing, but typically for $500, you can get the sheriff to go seize any property you want. He just needs your claim. How do you show the sheriff your claim? What do you show him? Your UCC1. Because he's in the public. All he needs is form. You just need to show him a public record and then bond him. And he's going to do whatever you tell him to do. Well, within the guidelines of the administrative laws.
Resulting of what comes out of the court?
What?
It wouldn't be what results come out of the court instead of the UCC1?
No, there wasn't. No, because he brought me to court. He tried to challenge it. The results were I won. I don't need to stand on that claim. Now, if I wanted, I could go file a court case on my claim, and I can get a judgment lien. And there's actually a special form from the Secretary of State just for a judgment lien. And it's even got a dollar amount on it and a signature line. That may even be more powerful than your UCC1, as a claim in the public, I mean, because it's got the dollar amount on it. Well, typically your UCC1 will also have the dollar amount if you're smart, but it's got a signature line on it. And the national forms, the UCC1 doesn't actually have a signature line. It's not a verified claim, but the judgment lien is a verified claim.
So right after you win that battle, then you could go back and...
Yeah, I could go to court. I could start a process here in B, because what am I going to do? I'm going into B to enforce my judgment that I got in A. Okay, I acquired the judgment over here, so I can bring it into B. That's tricky, doing that process. I know from experience, trying to get what you have over here recognized over here and get the result you think you want.
Is that judgment lien that you just mentioned, is that enforceable in B without a court case?
No. Judgment lien, you can only fill out the judgment lien form if a court case led to the document.
There was a guy in Washington, I think, was working for Boeing and had some issues with the IRS coming after his wages, and so then he went and put a lien on all the Boeing facilities and everything else and a bunch of stuff, but he got in trouble he kept doing it, and they finally, had to pull the liens off. Judge pulled the liens off, and then he kept doing, him and his wife kept finding all these things. They finally
And what was wrong with that? What was he doing wrong?
I don't think he was following the full process. He was
just filing liens.
Yeah.
So if you file a lien and you don't have something over here to back it up, not only is your lien not going to hold water, but you could probably end up in jail.
Yeah.
You put a lien on an IRS agent, a judge, something like that, and you don't have something over here to back it up. You got something over here to back it up, you can lien up anyone. You can lien up the President of the United States if you got something to back it up. If you don't have something to back it up, I wouldn't put a lien on anything or anyone. This must come before this. You must have the substance before you can put it into form. Okay? If you don't have the substance, I wouldn't play around with the form. Okay? Basically, form with no substance is like an empty gas can. Okay? Not very effective for fueling your process. But if you have the substance, the gasoline, and you put it into the proper form, the gas can, you can fuel your process, no problem. Now, what happens if you got substance with no form? You just throw gasoline all over the place, but you can't carry it. You can't hold it. It can't be recognized. It can't be made into a distinction. If the substance doesn't have some kind of form in public, then you can't enforce your substance. Make sense? Mm-hmm.
What would the expected cost be to perfect that process?
What would the expected cost be to perfect what process? This process we were talking about with notary
your presentment, all the cost of presentment and filing.
Well, I guess it depends on your notary and where you're sending it. Certified mail will cost you anywhere from $12 or registered mail will cost you anywhere from $8 to $20. If you start putting big, thick stacks of whatever in it, it'll cost you even more. The notary presentments, because the notary, see, this isn't like getting an acknowledgement or a jurat. It's not like a $10 thing, because the notary has to duplicate all the records, has to keep records. The notary's got to keep copies of all your records for as long as you're going to be enforcing it.
Can they keep digitized records? They have to have the actual...
You could probably keep digitized records. We're in the new digital millennium, and there's a whole bunch of digital records, digital signatures. It's a digital world, so digital records may be sufficient. I would keep a hard copy.
Can the notary keep digital records? Because where do they keep all that stuff?
My notary keeps it in a big file bin.
And for how long do they have to keep that?
As long as your deal with them is. Remember, it was made over here. So there are no regulations for how long she needs to keep those records over here because you made the agreement with her in jurisdiction A. So what is your agreement with her? I would say I would make sure that she's going to keep it for at least, 7 years? That's like an administrative timeout kind of thing.
One more question. On the address, someone sent something to me at an address I was not at, never lived there, and it was an ex-girlfriend's address. We had a joint credit card. Mm-hmm. They had that on file when she updated something. They sent it to me. I never got a thing. Then I get this lien against myself in the county for a default.
Yeah. They can default you on the wrong address. Yeah. Now, is their claim going to hold water if you can prove that you didn't live at that address? Because you could get a third-party witness to certify that you haven't lived at that address for so many years.
I never lived there. So.
Oh, you never lived there?
Never lived there. Never, ever.
So there's not even a public record of you ever living there?
No.
Okay. Well, then it's going to be kind of hard for their... See, now it's about whose record beats whose. You know, if their record has nothing of substance backing it, like did they have a process server deliver it to you and you signed for it? Never. Or did they just send it with a 32-cent stamp first-class mail? They don't even know if the letter ever got there. See, that's not going to hold up against registered, signed return receipt, certificate of service, copies of the presentment. You see how when you build the process over here and you're thorough and you keep good records, there is nothing that they're doing over here that's going to beat your process over here. For one, they would have, how often do you receive something that's certified and return receipt and you received it? Not very often. When they're trying to default you on your house, they do, don't they? Because that's involving quite a big piece of collateral. So if they were to just send you something first-class mail and then take foreclosure action on that, you could beat that easily. Because there's no verification that you were ever even given notice of the debt. And if there's no verification that you were never given notice of the debt, they really don't have a claim. Now, if you don't rebut their claim and you default on it or don't respond to it, their claim stands. Okay? So if no notification is given, how can it be a claim? They have a claim could be an invoice. Okay, we're talking about jurisdiction B over here. Okay, so if they've got QuickBooks, they could create a claim. If they've got Excel, they can create a claim. If they've got Word, they can create a claim. What I'm saying is there's no guidelines for that. If you're keeping the thorough records, like an invoice will only take them so far. If you're challenging it and you're challenging the validity and you've got evidence that contradicts their statements, then their evidence falls apart because they won't even sign it. They won't even verify it. They won't even sign under penalty of perjury that you owe that money. Not even with your house. They won't sign a verified statement saying, yeah, we loaned him money. Yeah, right. They'd be committing fraud. So they won't do that. So if nobody in the public is going to sign their name to anything to make a claim against you, who's got all the power? Yeah, you've got all the power. Remember we were talking about when you truly understand how to be responsible in commerce, you hold everyone to task. You think there's a corrupt person here or a corrupt person there in the government? Perfect a process. And you can get rid of them like that. Because once you get your claim and you get your record and you attach that to their bond, they're gone. And they'll never work for the government again. They'll never get insured. See, every public official must be what? Bonded. Bonding is like insurance. I perfect a $10 million claim against some corrupt official, and I liquidate that claim on their bond, what insurance company will ever bond that guy to work in that position ever again? No one, because nobody wants to lose $10 million. It's like if you had car insurance and your policy was actually $10 million and you were consistently getting $10 million claims against you, but you were only paying a couple $100s a month. You think that insurance company is going to keep you on as a customer? No, they won't bond you anymore. They won't insure you anymore. Like, no way, forget it. What about health insurance? If you have a pre-existing condition, do they bond you? Do they insure you? No, it's loss. They're not in it. They're not in it to lose money. It's the same with public officials. The bonding companies are in it to make money. You know, and the public officials, they don't pay a whole lot for those bonds. So I guarantee you get a couple multi-million-dollar claims against your bond, you ain't gonna work again.
Brandon, I'd heard that it takes 3 claims against a bond for them to drop you, but my question is, do you have to go to the county recorder to get a copy of the bond to find out what the number is?
You could do a commercial process to get that. If I made presentment to an attorney and I put on there that I have a claim and that she has 10 days to get me her the bond, whoever holds her bond, you know, what do they call that? Besides the bar, gosh, I'm totally lost for words tonight. Anyways, if you do a presentment on them, they don't respond, you've now got a claim on that bond information. You could actually now take it and get an order out of a court ordering her to supply you with that information.
What would be the damages, or how could you, they don't respond to the court order, then what? Did you have to stipulate that in your original process? If you do not...
They don't, well, then now they're in contempt of court. Does anyone here know all crimes are commercial? Did you know that? Yeah. Everything is commercial? What's the one thing you can go to jail for? Because when all crimes are commercial, even what you think are crimes, it's commercial. So there's only one thing you go to jail for. Does anyone know what it is? Contempt of court. That's the only thing you can go to jail for. In admiralty. Aren't we in admiralty? Okay. Well, in admiralty court, the only thing you can go to jail for is contempt. And when you plead not guilty, you're instantly in contempt. Yeah. Run that one through your noodle. Because not guilty is, well, first you stood up and you said you understood the charges. You're saying, I'm going to be surety for these charges. Right? Right. You said you understood, so you said you're surety. Now, when they ask how you're going to plead, how are you going to pay, and you say, I'm not paying, you're in contempt. You say, guilty, gilded, pay, I will pay. I plead guilty to the facts, Your Honor. I want to effect payment immediately. What's the sum certain on those penal sums? Done deal. It's all commercial. There's some questions in the front, you guys, too, so try to pass it up when you get a chance.
There was chatter online that due to California's credit rating lately, that the bonds for new court cases are not being purchased in the international market, and that now the prisoners are running out of food because there's not enough funds from their jail situation, and that if they can't get those things purchased in the future, they're going to start dropping cases and letting people out.
Interesting. So our bonds, our prison bonds, aren't worth what they used to be, I guess. You know why? I guess the population's probably gotten too high. Realistically, because it's all about production. If these inmates aren't creating enough production and a future value on those securities, nobody's going to carry the securities. They're not making the license plates. They're not making the computer chips. You know, if they're not doing those things, or there's too many of them to actually get enough work done, yeah, you'll start to see them dropping people out of jail.
Look how we house them. Look what they do in Arizona. They put them in a tent city.
Mm-hmm. Which the funny thing is, those bonds probably sell for a lot because he keeps his overhead so low. The guy in Arizona, the tent city, keeps his overhead low, so his bonds are probably worth more than the state-of-the-art prison facility.
You mentioned apostille from the Secretary of State.
Yeah,
Can you just briefly tell us a little bit about what that is?
Yeah,
please?
an apostille is a certification. It's basically all that an apostille is doing. It's the Secretary of State saying, yeah, that notary public is, that signature and that seal are a legitimate notary public signature and seal. So having the apostille on top of your document is saying that the Secretary of State is saying, all the Secretary of State is testifying to is that the information is accurate, that the notary signature and the notary seal is a valid notary, but the notary witnessed an event and swore to that event. So when the apostille or the certification is attached to the notary's testimony, you now have a self-authenticated document, because that an apostille or certification can be sent to any nation on the planet, and it is recognized as a legal document. Okay? The Secretary of State. Yeah, and if you're actually doing it in the United States, like if I'm not sending it from one, like if I were to make my claim from B to A, I can get an apostille. Okay? I can't get an apostille from A to B because they don't necessarily operate in A. Or at least the Hague Convention wasn't made with jurisdiction A. The Hague Convention, which is the agreement that all the nations agreed to certify documents this special way so that they would be acceptable all over the world, that's the apostille process. That's the Convention de la Hague. Jurisdiction A doesn't necessarily have anything to do with that, but check this out. I could actually, so an apostille is from one jurisdiction to a foreign jurisdiction. If it's from the state of California to the state of Nevada, it's actually a certification. If it's from the California Republic to Nevada State, it would be an apostille. But who's going to apostille something from the California Republic? when the Secretary of State's probably operating over here most of the time. Okay, or at least that's the Convention de la Hague was over there. Now, you may be able to get them to apostille something from a republic state to another republic state, but typically what you're going to get, rather than an apostille, if it's being done within the United States, is you're going to get what's called a certification, which is basically an apostille, but apostille is the international term. So if you go to the Secretary of State and go, yeah, I want to get this apostille, do you know what she's going to ask you? For what country? What country are you sending it to?
So you wouldn't get an apostille if you weren't, so if you were just submitting it as documents in a court locally. You just get a certification.
You would get a certification. Exactly.
What does that cost?
About $20 per document.
25 to 45, I think.
Yeah, I think I get them for about 20, but I walk them in. I actually drive up to Sacramento and walk mine in.
There's an extra fee for that, but I think by mail it was like 10 or 15.
Yeah, it's actually $6 more, but I get mine right away. They literally take it over the counter, apostille them, and hand them back. So there's no 10-day waiting, 14 days waiting, or nothing like that.
Don't they do that downtown LA?
No. If you go to the county, you could get it done in LA, but this is the process. Okay. See, I can take just my notarized document directly to Secretary of State, and I get an apostille. If I wanted to do it at a Secretary of State field office that's not in Sacramento, I would first have to take it to the county that my notary is commissioned in, and I would have to get certification from the county on her signature. Then I would take that to the field office for the Secretary of State, and the Secretary of State would give me an apostille on that.
That was my question, actually. How do you do certification?
Certification is the apostille process. It's basically when you go up to the Secretary of State window, you say, I want an apostille if it's going to a foreign jurisdiction. If not, I want certification. It's the same exact process, costs the same amount of money. If you ask for an apostille, they're just going to ask you, what country? That's the only difference in the process, what country.
So what we were talking about earlier when we were talking about getting a judgment, so let's say you took it into court, we really wouldn't have the apostille, it would be the certification because it's from state to state.
Yeah.
Yeah, we're involving a notary quite a bit in this. Is there any chance that they would be called into court as some sort of witness when they have notarized all your documents and that sort of thing?
It is a witness. Their documents are a witness.
So
and if they keep good records, they got nothing to worry about. See, I've seen a lot of the patriots out there, they prepare documents for their notaries, and the notary's basically making threats to whoever you're making the presentment to. That's not a good idea. And those same notaries refuse to keep records. So if you're as a notary, you decide you're going to sign, put your signature and seal on a document that's making threats to another person, and you don't keep accurate records, you're going to jail. I've known notaries, I don't know personally, but I've heard of notaries going to jail doing presentments because of that. They didn't keep records, and they made threats. The way you structure, remember, we're creditors. We're never making threats. We never need to go there. We're always coming from, hey, we're bringing a settlement. We're here to assist. We're here to help. We're not here to threaten you or to frighten you. And if that's your intention, be prepared to be challenged.
So you really have to find a special notary that, number one, knows her business and knows what you're about.
Yes.
And does keep records. So I think you have to really kind of interview them.
Yes.
Pretty precisely.
Yeah, I'm very particular about the notaries I use. They must keep very accurate, complete records, and they must have a commanding understanding of the presentment process. They must know exactly what it is. And for those of you, I thought of this as I was leaving the house. It's 2 documents I should have included for this week's documents, and I'll probably add them tonight or tomorrow. And they're 2 notary manuals. It's Anderson's notary manual and Piambino's And those are two very complete notary manuals. I happen to have a notary that was actually willing to learn all of this, and I pointed her in the direction of Piombino's and Anderson's manual, and I actually purchased all these manuals for her, and I gave them all to her. And she was willing to educate herself to learn this.
Can you spell Piombino's?
I can guess. Piombino, and Piombino was his name. Okay, let's see. Do you guys need a break? Okay. Alrighty, we'll go to break, and then I promise those of you on the phone we will get to questions from you guys too. Here we go. Can you hold that? All right. All right, I'd like to get in at least 2.5 hours per class. What do you guys feel? Right now we're running at about, and we've had an hour and 45 minutes of instruction or sharing, but I'd like to get in at least 2.5 hours each week. Would you guys mind if we went for maybe another 45 minutes? Okay. All righty.
Are you okay with that?
I'm open. So, alrighty. So we didn't even get into the other presentments or anything, but is there any more, or is there any questions regarding what we've discussed so far with the administrative procedure? Yep. Questions? Microphone.
I was just curious if you could give an example or two when we might, use something like this. It might seem obvious, but maybe you could give us some of your experiences or something like that.
You are to never use this. Okay? Does that answer your question? Unless you understand it and you know what I know, I wouldn't try any of this. Okay? It's easy to get tripped up. Just what I will tell you, I'll give you some good advice. Just think about, really don't take someone else's process and just duplicate it and change the names on it. Okay? Really read and understand it. If it doesn't feel like you're being a creditor, you're probably not. If you're creating a controversy, if you're not, moving in some kind of a peaceful, non-adversarial direction, just be mindful of any processes you do decide to undertake. Consider those words.
So you're saying don't be malicious?
Yeah, definitely don't be malicious. That's just never a good idea.
Ooh, I have a question. What's with these documents, these sealed documents in a court case? Is that A, B, when they say we're going to seal these documents, no one's going to see them, blah, 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 blah.
Yeah.
What's going on there?
Yep, private side. It's not necessarily jurisdiction A, but I would call it the private side of B.
Judge's chambers.
Yeah, judge's chambers is the private side of B. So, yeah, something that's been sealed, it's private and proprietary. Like, for instance, if Coca-Cola was suing one of its employees because he used their formula in one of his products, well, they don't want to put their formula into the court record on the public side because then everyone would have access to Coca-Cola's recipe. So what they're going to do is they're going to put it into chambers, and it's going to be held under seal as private and proprietary. That was actually a case? Oh, how funny. I thought I was making it up. Okay, any other?
How about, you said register?
Is it on?
Just flip it up.
Switch.
How about the address for registered or certified? Can we use mailbox, etc., or P.O. box?
No. You mean for your address?
Yes.
For your address you can, but you can't send registered mail from there. To send registered mail, you have to go to the post office. You have to physically walk down to the post office and give them registered mail. You can't put it in your mailbox. You can't take it to mailboxes, etc. You can't take it to any other location. You must take it to a post office. But you can use your address can be a mailboxes, etc. mailbox.
Oh, it's okay.
Like so, yeah. So if here's my envelope and my return address up here, that can be a mailbox, etc. address.
Okay. So either mailbox or PO box.
Right, because realistically, whose address should be up here? If we're doing a presentment from jurisdiction A, the notaries.
Oh, okay.
That's whose address should be up here, because that's who it's coming from.
So for you, which one is better to use? The notary or the mailbox, etc. that I'm using?
If you're doing a presentment and you're doing it as a claim like this, what we've been discussing today, you would want to do it through a notary.
I see.
Okay?
Thank
Because
you.
notary it's their official duty to keep the records and to witness things, whereas mailboxes, etc., they don't have an official duty to witness something that you do. Because I've heard of people using, like mail stops and things like that to actually be the witness for what they do. And actually, one of the guys who calls in on Tuesdays, he actually knows the Postmaster General, and the Postmaster General gives him a certificate of service, showing, yep, that's what was in the document from the Postmaster General. Yeah. So, or not, I'm sorry, not Postmaster General. It would probably just be the Postmaster, right? Yeah, Postmaster General, there's only one, right? Yeah. So yeah, he gets it from the Postmaster. The Postmaster certifies it for him. Actually, I should, but I don't. Alrighty. Let's see.
One more question, Brandon.
What's that?
The benefits of being a notary as to the possible negatives to be a notary. Which jurisdiction, are they a state and a federal employee by default in a sense, or how does that work as far as the notary?
Okay.
For someone to become a notary.
Are you a U.S. person?
Yes.
You are?
You
Are you a capital U, period, S, period, person? How about, are you a U, period, S, period, citizen?
No.
No? This is an agency, right? It's a trust. So if a U.S. citizen is a trust, a notary public, guess what one of the mandatory requirements for a notary public is?
Heck.
U.S. citizen. What about attorneys? They're U.S.
Bar.
citizens. They have a title of nobility, Esquire, but that title, guess what it gets tagged onto? The end of their name in all caps. Have you ever seen a court pleading where the names weren't in all caps? At least in the caption. It's not to say that an attorney can't operate over here, or that a notary public can't operate over here. Okay? But it's just a corporation. So if your corporation is going to be a notary public, who cares? You can make your corporation a notary public. Doesn't mean you can't operate over here. You can make your corporation into an attorney at law. Doesn't mean you can't operate over here. Remember, this entity, it's locked into jurisdiction B. It can't traverse. It doesn't mean if you're managing this entity that you can't traverse. You're not anything over here. Everything over here is dead and fictional. Everything in B is just a corporation, just a trust. And you're never that. You're never a stack of papers. So, you can be a notary. Your U.S. citizen can be a notary. You can't be a notary, but your agency, your trust can be. And I wouldn't say that I think the benefits are you can notarize stuff for people. You can witness things for people. That's kind of cool if you're into that.
Could you notarize your A-side papers that you would?
No, not your own.
No, not your own. And not anything that you would directly benefit from. really. Like, so even a husband-wife. Because if my wife is doing a presentment and it's regarding our house and I'm going to benefit from her presentment, I can't notarize any of those documents.
Otherwise, you're perjured or what?
It's a conflict of interest. Yeah.
So that notary's a state employee, and then
They're an agent of the Secretary of State. You're all the U.S. citizens are employees of the United States. All U.S. citizens are employees of the United States. All U.S. citizens are employees of the United States. What does that tell you? Is your U.S. citizen a government official? Yes. Your U.S. citizen is a government official. He's the lowest man on the totem pole with this title. But he's a government official. See, if I add some titles to that, let's see if I add ESQ to the end of my name, now I have more stuff I can do in jurisdiction B. If I add a MD to the end of my name, well, now I can do even more stuff in jurisdiction B. Does the MD on the end of my name mean anything over here? No. So can somebody agree to have an operation in jurisdiction A that is not governed by any of the things over here if it's a private contract between the two individuals? Yeah. And does the one operating have to be an MD? No. I'd be careful. But realistically, that's no more dangerous than all the other stuff we're talking about up here.
So, great notaries. Is there a list that we can find of ones that we've used that we like that are either in Orange County? I'm in San Fernando Valley, so I drive all the way down here.
There was a list. I don't know how great they are. I've got one notary, and I'm so glad I have the notary. She didn't show up tonight. This is like the one night she should have been here because you'd all be swarming her right now. But I don't know where to get them. I can tell you a resource I've heard of, but I can't vouch for it.
Well, anything's better than going, hi, you're a notary. Do you do this? Okay, no. Hi, you're a notary. Do this. And hi, you're a... No.
You go to what's called Notary Depot. It's NOTARYDEPOT at hush.com. It's an email address. Yeah, it's the same one Sam Kennedy uses. But remember, just because they're using an adversarial process doesn't mean you have to with these notaries. Now, there may be fewer and fewer notaries in that group if they're using adversarial documents, because I know that the people that I've heard of that have gone to jail have all been associated with those same types of groups. I'm not saying that anyone from this group has. I'm just saying that they affiliate and associate with each other. Okay, so there's a lot of adversarial blood. The one thing I would mostly be looking for in a notary, a creditor. One who just acts like a creditor in their life. You know what I mean? Not necessarily like they've got billions of dollars in the bank and everything's prepaid, but as long as they approach everything as a creditor and they're not a victim to the world, they're not a victim to the United States, they're not a victim to the police officers, they're not a victim to judges or attorneys. If they come from responsibility, that's the best notary, because that notary is going to take the responsibility to learn it. They're going to read Piombino's and they're going to read the Anderson's manual. They're going to want to understand it because they're responsible. They're not victims. They don't expect things to just be handed to them. Okay, so that's the one thing I would look for the most. You might want to just have one of your, if you've got friends. I know you've got friends that are in this. 2 or 3 of you could become notaries. And you guys should all study together and learn it all together. Because realistically, look at this network we've got here. We've got a room full of people. Yeah, start a study group and learn it. And it's really not that complicated. I learned the whole thing by myself, and I'm not even a notary, but I wanted to understand what they could and couldn't do. So that's just the way I am. I take responsibility. Yeah, because I take responsibility for what my notary is taking responsibility for. I figure I'm really the responsible one because I'm the one preparing the documents. And you never know if my notary is, half awake one day and she might not read a document all the way through and she might not catch something. So I got to take responsibility for that. Okay? So just be mindful of that you want someone who's going to be responsible and not be a victim to your process. Because if they already have that victim mentality, then they'll watch how fast they become a victim to you in your process.
Given the timeline you acquired to generate this information, could you give us an idea of how long it took you?
To learn the notary stuff? Actually, it didn't take that long at all. I went through Piombino's and Anderson's within a couple days. Really, it was, I think, the most intriguing stuff that I've learned about the notary publics and their duties and powers is when I was going through. Oh, do we need to change tape? Yeah, let's change tape. Go ahead.
Next class, can you bring some cards from your notary?
She'll be here. She comes every week. She just missed this week for some reason. So. Who is she? Deborah, the Latino girl. Her and Garrett sat in the back. They usually both sit up here. Yeah.
So it's warmer than next time.
Yeah.
He's ready to go.
All right. Alrighty. And where were we? Did I answer your question? Yeah. Okay.
It might be like a month or so on, or 2 3
Yeah, I would say really to get a good handle on it, you got to be practicing it. Like you can read all day long, but it's until you're actually preparing the documents and putting it all together, that's when you really start to learn it. Because just reading it, it's just it's not real when you're just reading it. You don't have anything physical that you've experienced to call on, and really that's where you get the most amount of your wisdom is from experience. So when you've experienced doing presentments and you've experienced going to the notary classes and everything else, because of course they will educate you. They don't educate you very well. They just give you a minimum curriculum. They teach you how to do acknowledgments and jurats. I think that's probably it. Because that's what most notaries do.
Was it 8 hours? You can get certified, right?
Something like that.
You take a class and then you take a test at the end, and you literally.
There's the microphone.
No, that's it.
Up here.
Are you going to try OID as well tonight, or no?
Yeah, we'll go over that. As soon as we wrap up the questions for this stuff, we'll go into the financial stuff.
Just a quick question, Brandon. If you have a notary in another state, can they execute documents for you, or is it best to use some? Because I know some good ones in Florida, but it's for California process. Can they still do it?
Let's think about it. Where's California on this chart here? It's in B, right? Where's Florida? B. Where are you at? Does it really frickin' matter?
I just thought since states are foreign to one another, if it made a difference.
You're not in them. You're over here. When you're making your private presentment and your private claim, you're coming from over here, so it doesn't matter. They're over here.
Yeah.
From where she's at.
Now, you can't have a foreign notary unless you're going to fly to Florida. You can't have them do jurats or acknowledgments.
Right.
But anyone will do a jurat and acknowledgement. If you need to do an affidavit, you pretty much take that to any notary in the entire country, and they'll do a jurat or an acknowledgement. So it's when but you can have, a notary in Florida can be making presentments for you, notary in Ohio, notary in Michigan, notary in Texas, doesn't matter.
Cool. Thank you.
In fact, I work with guys over in the UK, and a notary in California made presentment of a commercial process on a bank in the UK. And she presented evidence under seal to the judge in chambers in the UK. So that's the power of a notary. And because they were apostilled, I apostilled them for the UK, that's evidence. And trust me, Bar Association all over the world, it's the same exceptions to the hearsay rule are the same. You know, the evidence, rules of evidence, that's something you really, we're not getting into courts yet, but that's where we're heading, you know, in understanding the court process. One of the most essential parts of the Code of Civil Procedure to understand is the rules of evidence. Rules of evidence are essential to understanding. If you ever want to take your claim from here over to here, you're going to want to understand the rules of evidence. And there's the Federal Code of Civil Procedure, and then California has its own Code of Civil Procedure. And actually, California has evidence code that's actually separate from the Code of Civil Procedure. So if you guys, I don't know if you've been on the resources section, if you go into down at the bottom, it's got agencies or something like that, and it's got United States, United Kingdom. Click on United States, go down to states, click on California, and there'll be a link for California legislation. It's like basically you check what type of code you're looking for. So you could click commercial code and then put a search term in there, and it'll bring up everything from the commercial code having to do with that. That's actually how I found the notary thing without the United States. I actually was looking for anything because I knew what without the United States meant. And the funny thing is, I wasn't even looking for anything pertaining to a notary. I was just looking for, I want to see where they mention in the code things happening without the United States. And in the government code, it was notary stuff that came up. I don't remember. I was only interested in the notary stuff. There may have been. There probably was. There probably was other stuff having to do in the government code. But there's literally, I would say there's probably 30 different types of code listed on the California legislation website. From commercial code, vehicle code, evidence code, criminal code, civil procedure, civil code. I mean, it's ridiculous.
You can just Google, too, California codes, and
Yeah.
that same page will
Yeah, that same website will come up. That's probably how I found it. Okay, anything else on administrative procedure? Back.
I just wondered if you'd heard anything about like doing an apostille yourself. Like there's a software kit that's like $20. Have you heard about that?
Doing a what?
Apostille.
What do
Getting
you
something
mean
apostilled. Yeah, there's some, like, because I was looking for one when we were trying to do county recording of documents that we don't want to do. And they wouldn't get apostilled. Like I called a notary, and he was like, he actually called the Secretary of State to ask about these particular documents. You know, it was like, you know, state citizenship, declaration of state citizenship, and things like that.
Oh, okay.
And he was like, no, we can't do those. But you know, he said, you know, you can get them apostilled yourself. And he gave me this website, and there was like a kit for $20. I just didn't know if you'd heard of it. I'll look for it and see what it's about. But I don't know what that. I mean, I know we never did it, so.
Okay. See, the thing is, I don't know if that apostille means the same thing. Because apostilles, I've been discussing them, or as we've been discussing them, it's from, the Convention de la Hague, which basically there's a whole bunch of countries that signed on and agreed that this was the convention that we were going to go by. I'm not a signatory, so I can't apostille.
I'll look for it.
Okay. Maybe there's something about apostilling from jurisdiction A. That's a possibility because guess what? All the positions in A of the Republic, they've all been abandoned. Did you guys know you could become a county notary? Did you know you could become the postmaster for your city? In jurisdiction A, not in jurisdiction B. Jurisdiction B, you got to be hired, and you got to go through a whole process. But in jurisdiction A, all positions have been abandoned.
How about judge?
An Article 3 court, but you'd have to create the court. Actually, no, you could actually get the court to let you use one of their courtrooms, and you could hold a hearing in there. In fact, if you had, is it 7 notaries or 9 notaries, a petty jury? Or wait, maybe it's 5. If you get 3 notaries together, you have a tribunal. You can get 3 notaries together, get into the courtroom, and you could hold a hearing in the court. with 3 notaries. So it's funny because, you know, it's not like B can't eliminate A. You know, B was created inside of A. So there is some traversing that can go on. And that's why when we talk about the private side of B, that's typically where you're going to have transitions between A and B. It's going to be coming through this private side of B. Because remember, when I brought my evidence into court under notary seal, private and proprietary, it came to the private side of B. Things flow no problem between the private side of B and A. Does the bankruptcy of B have an effect on A? Well, the bankruptcy of A created B. Does the bankruptcy of B affect A? Not directly, indirectly, but it because basically B was created by A, it can't really affect or change A. It can't interact with anything in A, or it can't regulate A. It can't control A. A controls B, always. A controls B. That's just how it's set up. So that's why, remember we were talking about those particular positions in the government that sit on both sides, that expatriate, and the post office. The post office is really where the power of government comes from, because the post office is sitting here in A, and then all the agencies that have been created, all these administrative agencies, federal administrative agencies, were created out of A, and the only ones sitting over in A are the post office. So realistically, that's where power in the agencies comes from, or where B comes from. B stems out of the postal jurisdiction. For if B can affect A, you mean with the debt and things? Well, you're going to remember, for a creditor, all that happened, all these administrative agencies that were created, you know, the over 100 now that are probably created since 1789. If you're a creditor, it doesn't matter. None of them ever affect you. Yeah, they can create another 100 agencies. If you're operating as a creditor, it doesn't matter. It's not going to hurt you.
What if they hyperinflate the currency that you're using on the public side?
Take responsibility. Don't use their currency.
Yeah, well.
Right? Martial law? When does martial... See, and this actually, you know what? This is a good point. Because I don't think we've talked about this yet. How many of you, if the complete infrastructure of the government went away tomorrow, how many of you feel comfortable that your neighbors and you would all get along because you're all creditors?
Where are you living in, Brad?
Okay? Now, are those people in your community? Who are they a reflection of? Okay? You don't trust the people in your community? They don't trust you. Being a creditor means being in the heart, coming from love. And we asked today at the beginning of class how many people had already used this technology. I wasn't even talking about this stuff, the physical, administrative stuff. I was talking about the spiritual stuff, because this is something we should all be practicing every day, realistically. Because when you do get challenged and you're doing it over here, it's going to be a whole lot easier if you already act that way with all the people in your life. You know? And right now, the fact that you're uncertain about the condition that you feel your community would be in if the infrastructure failed, take responsibility. Start talking to your neighbors, maybe. You know? Start sharing with them. Remember, being a creditor comes from abundance, right? When we get greedy and we're coming from scarcity, we don't share and we turn on each other. And that's what's been going on. And that's what will happen That's why you hear me up here touting, yeah, woohoo, one world government, bring it on. I want it. Because that's what's keeping everyone in a responsible role. Realistically, without that one world government, what are the benefits of the one world government? Anyone?
One banking system.
Common commercial system. Isn't it? I mean, we're really, the funny thing is, where did the global government come from? It's a reflection of your global community. You now have the power to communicate with every single person on the planet the blink of an eye. You've created a global community. Of course you're going to have a global government. You know why? Because you want it. When you see Burmese kids, 10 years old, slaving, making sneakers, you want to regulate them. You want a one world government that agrees with your morals to step in and stop it, don't you?
Nike does it.
So, do you see, isn't it possible that this one world government is a reflection of our one world community? That we've connected, we are the ones creating a one world government because we're conscious. We're conscious of the globe. We want everyone to be taken care of. We send food to Africa, we send medicine to Asia, we do all these different things, sending all these different things, different places, and we create these agencies to regulate that. We want a uniform commercial system or code. We want this uniformity between all the nations because we're a big community now. We're one big community. And if we're all one big community and we're all acting like creditors, is there any war? No. Is there any hunger? Is there any scarcity? We'd all be coming from abundance. We wouldn't be afraid of people jumping the border and taking our jobs. That's coming from scarcity. It's a global community. Borders are freaking imaginary. They only exist on maps. They're arbitrary lines somebody drew on a map. But there are people on every side of every border. And if we're not treating all of those people as creditors, or we're not acting as creditors, and we're not sharing and coming from abundance, not from greed and scarcity, it's funny. How many have heard the term, money is the root of all evil? I'm sure everyone's heard it. How many of you believe that? It's not money. It's greed. Has nothing to do with money. Because we could get rid of money. And what if we used apples as currency? Or we just traded our goods and our services? You mean to tell me that people wouldn't be greedy with their goods and services? They wouldn't be hoarding them? They wouldn't be afraid of not having those resources? They wouldn't be afraid of being in scarcity, of not having enough? And that's just a choice. Fearing not having enough is a choice. You can choose to come from abundance and share and watch how it reflects back at you. Did you hear the few stories that were told tonight about people who are using it in their life? You see how it's coming back to them? Like, yeah, we may not give too much stock to a fun experience with an IRS agent on the phone. But think about what you just did. What did you create? That agent, 9 times out of 10, is probably dealing with somebody who's a serious belligerent debtor. Puts them in a certain state of mind, and then they turn around and treat the other people on the phone that way. And it spreads like wildfire all over the world. We all treat each other like shit. Yeah. I mean, if it's not, remember, it's all about your intention. If your intention is to love, your intention is to give, your intention is to be abundant, you're going to start to see it get reflected back at you. If you stop being afraid and living from scarcity, watch how that tight grip you hold, as soon as you let it up, things just come. They just start flowing in and out. They got to be flowing out too. And your intention can't be, I'm going to give this so that I get something back. That's not the intention of a creditor. Maybe in jurisdiction B it is. But we know the guys who call themselves creditors in jurisdiction B, they ain't creditors. You're the creditor. They call themselves creditors. They list you as a debtor on a credit report. But who's creating all the money? Yeah. So they're not creditors. They call themselves creditors. So yeah, they're in it because they're coming from scarcity. To them, it's all about the bottom line. But if we all come from side B and worry about the bottom line and being in the red and being in the black, then you have an implosion. Because everyone's afraid of everyone. No one wants to share with anyone. This is the most valuable information on being a creditor I can give you. Really. Because all this stuff that we talk about as far as procedures and processes, really, I'm giving those to you so that you have something to work with, so you can take responsibility for this cluster mess over here. I'm trying to keep it clean. I'm a vulgarian half the time, so. But this is a mess. And if we don't take responsibility for it and start acting like people who belong over here, things won't go how we want them to go. And I know that there's a path we're heading down right now. I feel that we're at a crossroads, so to speak. Yeah. And we could either be afraid and run and come from scarcity and watch how we tear each other apart. Because remember, that one world government that so many people want to fight against, if it were to disappear tomorrow, you'd be a lot scareder than you are now. Only because we don't have trust. Trust in our fellow men. It's funny because a conference call we did months ago, I wanted to do a thing on trust. And as I started researching trust, I started to realize everything was a trust. I can't come up with one transaction, entity, or anything that exists in commerce that isn't a trust. It's all trust. So what happens when everything's trust but nobody trusts? They become dysfunctional. But everything you're doing is in trust. And remember, we talk about forgiving debts. So, whose debts do you have to forgive before you forgive anyone else's? Your own. And guess what? Guess who you have to trust before you can trust anyone else? Yourself. Because your lack of trust in others starts with your lack of trust in yourself. I know this. That's probably the hardest thing for me personally, for me to overcome, was my trust. Not trusting myself. Even doing these classes, it was a struggle for me to trust myself that I would actually be able to stand up here for 3 hours every week and come up with something that you guys consider valuable. And last week was probably, in my opinion, It was the worst class I've ever done because I tried to stick with some kind of a guideline for it. I was like, okay, I've got this document and this is how I want it to go. I was attached. I drew a little box for the class of our possibilities last week. This week I was like, I can't do that. I'll bring some documents and we'll talk about some documents, but I'm not going to lay down like, here's the framework, here's step A, here's part 1, and this is how we're going to do it. Because that limits us, puts us in a tiny little box. Whereas, if we're in the question, infinite possibilities. What happened to the microphone? Oh.
Ask a question. You say the circle of B was created within the circle of A.
Yes.
Right? To your knowledge, are there any other circles within the circle of A that we don't know about? I mean, yes, we're learning about being a creditor and debtor and all that stuff, but is there anything else in existence around us that's like a C or something like that that we haven't talked about?
Well, realistically, when we talk about A and B, typically we're doing a jurisdiction conversation.
Private and public.
Right, but I mean, United States is its own jurisdiction. State of California has a jurisdiction. Mexico is a jurisdiction. Realistically, A, and remember when we did the breakdown of jurisdiction X, jurisdiction A, jurisdiction B? So really, everything comes out of X. So if you want to say what's above A, only X. Okay? And X is purely private. It's whatever you and some other being decide. The law is whatever you decide it to be. The contract is whatever you decide it to be. That's the only time you're operating over an X. A is a society. We got together, we decide upon a common law, a common way of interacting with each other. Okay, and that was, somewhat codified with the Constitution and, these documents that, it's not that they're bad, they're just not necessarily what we always thought they were. But that common understanding that we have. Like, we have a common understanding that if somebody just comes up and punches you in the face, that ain't right. We've decided that as a community. We've decided that as a community, if somebody kills another person intentionally and with malice, that person is put away. Now, some may make the argument that they should be destroyed and killed, eye for an eye, kind of common law kind of thing. Let's go back to law of the land. That's what you would get, execution on the law. He would be executed. But what separates law of the land from admiralty? Mercy. Admiralty has mercy and forgiveness. You don't have that in law of the land. Law of the land is execution on the law. So, whenever you hear the arguments being made that we should be back on the way things used to be, think real hard. If that's really what we want. When we've demonstrated tonight how what we have as a global commercial system, it's got to be the ultimate system for a responsible person. Someone who's willing to take responsibility and create of their own claim and not depend and be a victim to something else. Responsible people have unlimited potential and capacity. Unlimited. And that, to me, is the beauty, the absolute beauty of what we have. Because no matter what you want to say, no matter what you want to point your finger at about what's wrong with the system, the one thing that I can say is right is that is rule of law. It's rule of contract. You agree, one way or another. You never go to prison without volunteering. I guarantee that. You volunteer the whole way. Okay? So it's a beautiful system. That's all I can say. And all I would fear is the rule of law not being the highest order of things. See, the funny thing is, there was a quote. You guys should read that administrative thing from the Wikipedia thing, because there was something in it. There was a quote, and actually, let me see if I can find it. There's a purpose, history, 946. Okay. Great. I don't see it. All right. Well, we'll read it. There's some really good stuff in there. I don't see it offhand, but basically, during the time that most of these agencies were getting created in the 30s, there was a lot of political turmoil. It was a very passionate battle whether or not to allow the creation of all these federal agencies. And the Republicans on one side going, hey, less government, less government. Democrats going, more government, more government. And what they decided was that this administrative standard would give us extensive government without dictatorship or central control. See, there's a guideline that all the agencies are bound to. Nobody can act outside of it. So we're all under the rule of law, under the rule of contract. I'm not saying anything has authority over you or anyone has authority over you. You choose. You either choose to operate over here and be subject to whatever rules you're operating under over here, or you can operate over here and operate under free open contract, free commerce, international commerce. Because realistically, every agency, even these Jurisdiction B guys, have the capacity of doing international commerce. That's why they had to have this administrative standard. If there wasn't this administrative standard worldwide, we wouldn't be able to protect our own interests in foreign nations, and foreigners wouldn't be able to protect their interests in our nation. And we're a global community. If we're a global community, we need to be able to protect our interests no matter where we go. And that's what we've been given. And that's the beauty of it. That's why you will see eventually the collapse of all dictatorships. They'll all be gone. Because in reality, they can't function in this system. That's the main reason. It's not that they're bad. They're neutral. But the fact is, there needs to be an administrative standard by which all those entities in that nation operate. And if there's a dictator who has the final say on how things go, then you're not operating on an administrative standard. It's tyranny. And this American experiment, a lot of people like to call it a Masonic experiment. And the one thing Masonry pledges against to protect the people from tyranny. You know where the word America comes from? Did we already do this? No, that's what they tell you. Whenever you have a followed by a consonant in Latin, it's like no. Like What's an example? Apolitical. Right? Agnostic. It's not knowing, right? Because Gnostic is to know. So agnostic. Okay? So no. Latin for mercy. It's actually, I believe it's a Gaelic or Latin for a flock of sheep. No mercy for the sheep. Are sheep debtors or creditors? That was nice. Debtors. Okay, so America. No mercy for the sheep. No mercy for the debtors. This country was established so that if you choose to be a creditor, you have absolute control. If you choose to be a debtor, there's no mercy for you here. Seems like a very cruel system to debtors. Aren't debtors the biggest victims? Yeah. They're the biggest victims. They're a victim to everything. They're driving through a parking lot and somebody pulls in front of them and takes the spot. They're a victim to that person. You stole my spot! I've seen people get so angry. They're yelling. They get out of their car and they want to fight because of a freaking parking spot. Can you imagine if all services and electricity and clean water all of a sudden were turned off? You know what that person would be doing? Walking around with a sawed-off shotgun, breaking down your door and stealing your can of soup.
That's why they have 800 FEMA camps already set up.
Yeah, that's why they do. It's not because they're going to put the creditors there. It's because there's no mercy for the sheep. No mercy for the sheep means if you're going to be a debtor, we're going to have to lock you up. Maybe you'll go under the iron yoke, so the wooden yoke. Maybe you'll become a food product. What's that? Iron yoke is when you're taken into slavery in a foreign land. Wooden yoke is when you're in slavery in your own land. It's a biblical term, being under the iron yoke, being under the wooden yoke. Yeah, we're getting about there.
Mary comes from what language?
I believe it's Latin.
Oh, that's Latin as well.
Mm-hmm. And I'm not sure. Look this one up. If you're going to look it up, look under Gaelic and Latin, because it may be a Gaelic word.
Quick question, Brad.
Mm-hmm. Microphone.
Hypothetical situation. Seattle, 1999, World Trade Organization. Hi, everybody. I'm a creditor. Was it 1999? No, I'm just saying that's when they had the big. 99. Okay. So let's say the police are there and they have a little free speech zone, and I say, "Hey guys, what's happening? I'm creditor here. I'm just going to go over here and protest. I don't have a contract with you."
Protest?
No. But I'm asking questions. You know what I'm saying? So
you're asking questions to go protest.
No, I'm just.
That's like, well, I'm asking a question. Hey, is it okay if I go beat the shit out of this guy? Is it all right? Is it all right? Is it okay? Hey, do you mind if I beat the shit out of this guy? Would it be prudent for me to beat the shit out of you? You see, you can ask questions all day long. Doesn't mean you're being a creditor.
I understand that, but if I go there and say, "Hey guys, I'd really like some answers. What is this all about? Why are you doing this?" And let's say I have a bullhorn because I don't really have any way to communicate with these people because they're not allowing me to communicate. So what I'm saying is it's all well and good that you have these institutions. Mm-hmm. However, I believe they have usurped power and grown far beyond their means. And so I'm just saying that this is how
I know exactly.
This is how people are going to respond. It's
Where is their power at? If we're talking in the world of jurisdiction A and jurisdiction B, where do they have power?
If you have an officer of a corporation with
Where
a
do they
fire,
have power?
listen, you have
Are
a
you
firearm.
refusing to answer my question? Where is their power? What do they have power over? B or A?
A has power over B. That's who gives B the power.
Right. And where do they exist? Where's the World Trade or whatever?
Well, they
we're talking
exist in B.
about? Okay.
Right.
Okay. So why do we care? It's Disneyland.
But if my car is impounded at the barrel of a gun and that person has no contract with me and they're using force, you see what I'm saying?
You have a contract. If they're repossessing your car, or are you talking about like a carjacker?
I'm just saying there are some uneducated people in jurisdiction B who don't know, but believe
but you can
they
operate
do.
from over here. You can attach to their bond, and they will not ever do that again. Right? Couldn't you?
After you've been assaulted.
I'm not saying you won't be assaulted.
Right.
I'm not. Did I say anything about creditors being immune?
No, no, no.
No, they're not immune. Being a creditor does not mean you have immunity to anything. It means you're going to be faced with all the things you're already being faced with. How are you going to handle it? That's it. That's all being a creditor is. Your lives are, what you are confronted with in your life isn't going to change. But ask yourself, has the way you've been handling it been working for you? If it has, then I say go ahead and go back to being a debtor. That's the way you want to operate. But if it's not working for you, and you want to maybe create some different results in your life, it's all about how you react and how you handle the things that you're confronted with. Because the things you're confronted with aren't going to change. There's still going to be stupid people. You're still going to get aggravated.
Sure.
It's still going to happen. People are going to abuse each other, verbally, physically. It's going to happen.
And the reason I'm asking this is because I have people that are going to listen to this tape who are going to ask that same exact question, and I wanted to hear the answer so that I'm not being asked the same thing.
Are you taking the position that there is an answer?
There is, for a situation at that given time, there may be. Now, I'm not saying there's one panacea, but people have to have a frame of reference.
Do they?
Sure. Don't they?
Is your position the position? Is your position truth?
I don't know. I don't know.
So if you don't know, but you're choosing to take a position, are you being a creditor or a debtor? You're taking a position.
I understand what you're saying. Yeah.
And he's looking for a shield, too.
It's as soon as we think that there's an answer, that there's a right way, that there's a wrong way, that's not a creditor approach. It's funny, like I said, you guys, this is actually, it's going to be hard to integrate it into your way of being because we're so programmed to always react and come from being, I'm speaking of I, but it's something that it's all about taking in and accepting whatever the situation is and providing a remedy. Being the creditor. Those are simple words for a very, I wouldn't say it's a complicated thing, but it's more about where you're coming from, where your heart's at, and what your intentions are, than the actual doing, like the processes and all that other stuff. That has nothing to do with being a creditor. It just doesn't. A creditor can operate on both sides, but just because you do an administrative process, that doesn't make you a creditor. Just because you file a UCC document, that doesn't make you a creditor. Just because you accepted your birth certificate for value and sent it to the Treasury, that doesn't make you a creditor. Being a creditor is your intention and how you interact with each of the people in your life. When you get confronted with something, when your wife let's say you're married, and your wife, you know, I know because I've been married, and if I'm watching TV or reading a book or doing something that I'm currently occupied with, and she asks me to take out the trash. Now, that could be a very simple thing to handle as a creditor. But if we both choose to be debtors, that simple request could lead to shit being thrown across the room, people leaving and yelling and screaming. Like, it can get crazy when you have two debtors. It can get crazy. And I've been there. I've seen what happens when both parties act like a debtor. It's like, who can be the biggest debtor? Okay? But in reality, all it would have taken was for me to just accept, set aside what I was doing, or negotiated with her in a way that I was asking a question, posing a possibility, rather than saying, I'm busy, and not honoring her. Because that's what I'm doing when I say that. Like, yeah, in my head, I can justify, hey, I'm busy, I'm doing something. But that's a dishonor. And if you can't honor and respect all of those in your life, and I mean those you don't even know. You know, when you're walking through the grocery store and you stop your cart so that somebody can pass, that's a courtesy. That's something, that's giving. You know, you could be the guy who just keeps on walking with his cart. And say, no, you're going to wait until I pass. Are you the guy on the freeway who speeds up to catch up to the guy in front of you so that the guy next to you can't get over? Are you that guy? That's a debtor. Creditor will instinctively know this guy wants to get over, and he'll let off on the gas. I mean, how much time is he going to lose? 5 seconds? 10 seconds of travel time? Something that's just so simple as letting him into traffic. But you get two debtors on the road, and the one's speeding up, and the other guy's like, well, fuck this guy, I'm going to cut him off. So you got one guy speeding up to the car in front of him, the other guy speeding up to cut him off. Next thing you know, they're shooting at each other. Road rage. Okay? That's, and I'm not saying that you're necessarily the same as them, but just taking that little debtor action could push them over the frickin' overboard. Yeah. The debtor threshold. Yeah. All right. Well, any other questions about what we've gone over? Because I've actually gone a little bit over the time I said we would go, but I think we've been enjoying it. I'm open. I'll go as long as you guys want to. But
Somebody asked me about sending in the acceptance for value on the birth certificates. How do you know that they have received it? Is there any verification of that, or do you suggest we do registered mail?
Registered mail, return receipt. You'll get a signature on a green card that says I think it's always the same girl too. So I don't know, she must sign a lot of stuff.
She stamps his name on there.
No, it doesn't have his name on it. It's a girl's name. I've seen it thousands of times. I can't even think of what it is. Yeah, she signs a green card. What is her name? I forget. Actually, I could actually bring up a record right now and tell you.
And that satisfies. I mean, as long as we have that, we're good to go then.
Well, you know they got it. Wasn't that the question? How do I know they got it?
Mm-hmm.
Well, if you've got a green card back and it's got a signature on it, they got it. And even if you don't get the green card back, because those don't come back 100% of the time, folks, just so you know, Form 3811 is easy to get lost in the mail.
But they have tracking numbers.
Exactly.
You can track it.
And you kept a what?
Receipt.
A record.
A record of it.
You've got a record, so you know your numbers, you know everything. So all you have to do is call the post office and go, yeah, want to know about this registered mail number. Yeah, it got there on this date at this time. So-and-so signed for it. Would you like us to send you a copy of that signature? Yeah, please.
Thanks.
The purpose of doing the acceptance for value on the birth certificate was what again?
Oh, well, what's the purpose of it?
Yeah, I missed that class apparently.
Well, have we talked about accepting things? And when you accept something, to put a banker's acceptance on it, what that
Apparently
signifies?
I missed that class.
Okay. Well, basically, if you make me an offer and I accept your offer, what position am I in regards to title on that transaction? I control it. When you control it, what type of title is that? We talk about equitable title and legal title. You have legal title to that transaction now. When you accept, just by accepting, do you see the power in accepting? Yes, honey, I'll take out the trash. Boom, you're in control. You may not think you are, but ultimately you are.
Could you go over the benefits of accepting for value the marriage certificate?
Taking title to that corporation that was authorized by the marriage certificate. Benefits. I don't know. You control it.
Because I just remember in a previous class.
If there's kids involved, then you control. That's one prong of controlling what happens to those kids. You know what I mean? The marriage certificate is basically a authorization for a corporate merger. And that corporation creates little corporations, subcorps, subsidiaries, right? You get the average American corporation
2.2.
has 2.5 subsidiaries. Yeah. So you've got your 2.5 subsidiaries, and those subsidiaries, because you registered them with the state has legal title to those subsidiaries. So if you want legal title and thereby control of those subsidiaries, you're going to want to take whatever documents have handed control over to someone else and take legal title to it. And isn't it beautiful? In the whole public record system and everything all comes out of Administrative Procedure Act. They were making sure you had the ability to take control of these things. Because if it was just up to any county to decide whether or not they were going to record things and whether or not they were going to give you access to those things, that's tyranny. And they didn't want to make it possible for tyranny in any form. They're not just talking about like the Antichrist who sits up at the top of the world and I control it all. They're talking about the dick down at the court who controls just that stuff. Because if there wasn't some kind of guidelines that they all had to operate by, you'd have little tyrannies everywhere. Because everyone's debtors. They're all debtors. There'll be a tyrant when they get a chance. You give a tyrant a position, and he's going to be, or you give a debtor a position, and he'll be a tyrant. What's that? Oh, of course. But if everyone's acting like debtors, who's responsible for that? I am.
So if I accept for value our marriage certificate, what is the process then do I accept for value my children's birth certificates as legal guardian? Is that what I do?
A good idea. Do they have Social Security cards?
Yes, I do.
Okay. You just be mindful of all the contracts that have been created and anywhere where title may have been subrogated or rights may have been subrogated, and then maybe create some records of your own. If your kids are subsidiaries and they're all little corporations, what is a way you can protect those subsidiaries, those corporations? Inform. Remember, jurisdiction B is all about form. Could I put a claim on those subsidiaries? Could I put a lien on those subsidiaries? If I'm first in line, first in time lien on those subsidiaries, who can touch them? No one. I have legal title. Niall, who has legal title to your house?
You do.
That's right. Who thinks they have legal title?
The county. Actually, the bank.
They both think they do. But guess who they had to call when they wanted to sell it? Me. They wanted me to sign a quitclaim deed. Now, was I on your deed of trust? No. Am I on the grant deed? No. But they can't sell that house without my approval. Because I hold the first in line, first in time lien on that property. I have legal title. You can't touch those kids.
So then,
show me your claim. Show me your claim, Mr. Department of, what are the people that take your kids? Department of Child Services? Child Services. Show me your claim. Now, remember, only a responsible person would be able to even perfect that claim. You know, you don't want a bunch of debtors putting claims on their own kids. You know why? Because they'll beat and abuse them, and then we can't protect them. So you want that government there. Because not everyone's responsible. If we were just all left to our own devices and we were all immune and we were all acting like debtors, this would be a scary place to live. Because people choose not to be responsible.
So then, in the description of the UCC1 statement, then would it be just their names, or it's their names and has to describe like has their social security numbers?
For one, you can't supposedly you can't put social security numbers
In the UCC.
on a UCC. What makes a number a social security number?
The dashes.
The dashes and where they're placed. Same with assessor's parcel number. Same with a QSIP number. Do you guys know what your QSIP number is? I'll show you. QSIP is, what is QSIP? It's some kind of securities tracking number. I forget what it stands for. But, okay. So, let's say this is my social security number. Okay? 123-45-6789. Right? What's my QSIP number? It's 12345-6-78-9.
How do you spell QSIP?
C-U-S-I-P. Okay. So it's where you put the dashes, make the number what it is. So what they've said is you cannot put a social security number on a UCC form. But you can put QSIP numbers. Doesn't say nothing about not putting EINs on them. 1, 2, 3, 4, 5, 6, 7, 8, 9. They just move the dashes around. That's all they do. Add some dashes, take away some dashes.
And what's that?
That's the EIN. 2-7 numbers is EIN. 6-2-1 is QSIP. 3-2-4 is Social Security.
About the acceptance for value, or if we're doing acceptance for value or money orders, let's say I get a notice from the IRS saying you owe $1,000, and I do the acceptance for value. You send them the original because that's the instrument, or do you send them a copy of the original and you keep it?
Say that again?
You get the notice from the IRS saying you owe $1,000. And the acceptance for value, I write the verbiage, I sign it, I date it, pay to the order of the U.S. Treasury.
Right.
Now, do you send them the original back?
And when you say original, you mean the actual document you wrote accepted for value?
Exactly.
Yes.
Right. Okay, good.
Now, who had title to it?
I did have title.
Because you accepted it for value. So you accepted it. So you control the transaction. You're saying, here, use that.
Got it.
Right? That's why they're going to use it or not, depending on your approach. All right, we're running out of time here. So looks like we're going to wrap it up right here. Sorry, if you got any questions, let me finish packing everything up before we go. Anyone on the phone have anything to ask before we go?
I think you got 4 minutes.
I'm going to take that as a no. Did you guys know you're muted? Do you know how to unmute *6? All right. Silence is acquiescence. Thank you, everybody.
Thanks, Brandon.